Mr. Chief Justice Waite delivered the opinion of the court. This case comes herewith. A certificate by the judges of the Circuit Court for the District of Louisiana that they were divided in opinion upon a question which occurred at the hearing. It presents for our consideration an indictment containing 16 counts, divided into 2 series of 8 counts each based upon Sect. 6 of the Enforcement Act of May 31, 1870. That section is as follows: that if 2 or more persons shall band or conspire together or go in disguise upon the public highway or upon the premises of another with intent to violate any provision of this act or to injure, oppress, threaten, or intimidate any citizen with intent to prevent or hinder his free exercise and enjoyment of any right or privilege granted or secured to him by the Constitution or laws of the United States, or because of his having exercised this, such person shall be held guilty of felony, and on conviction thereof shall be fined or imprisoned or both at the discretion of the court, the fine not to exceed $5,000 and the imprisonment not to exceed 10 years, and shall moreover be thereafter ineligible to and disabled from holding any office or place of honor, profit, or trust created by the Constitution or laws of the United States. 16 Stat. 140. The question certified arose upon a motion in arrest of judgment after a verdict of guilty generally upon the whole 16 counts, and is stated to be whether the said 16 counts of said indictment are severally good and sufficient in law, and contain charges of criminal matter indictable under the laws of the United States. The general charge in the first 8 counts is that of banding, and in the second 8 that of conspiring together to injure, oppress, and intimidate Levi Nelson and Alexander Tillman, citizens of the United States of African descent in persons of color, with the intent thereby to hinder and prevent them in their free exercise and enjoyment of rights and privileges granted and secured to them in common with all other good citizens of the United States by the Constitution and laws of the United States. The offenses provided for by the statute in question do not consist in the mere banding, conspiring of 2 or page 92 U.S. 549 more persons together, but in their banding or conspiring with the intent or for any of the purposes specified to bring this case under the operation of the statute. Therefore it must appear that the right, the enjoyment of which the conspirators intended to hinder or prevent, was one granted or secured by the Constitution or laws of the United States. If it does not so appear, the criminal matter charged has not been made indictable by any act of Congress. We have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from the others, and each has citizens of its own who owe it allegiance and whose rights within its jurisdiction it must protect. The same person may be at the same time a citizen of the United States and a citizen of a state, but his rights of citizenship under one of these governments will be different from those he has under the other. Slaughterhouse Cases, 16 Wall. 74. Citizens are the members of the community to which they belong. They are the people who compose the community and who, in their associated capacity, have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as their collective rights. In the formation of a government, the people may confer upon it such powers as they choose. The government, when so formed, may and when called upon should exercise all powers it has for the protection of the rights of its citizens and the people within its jurisdiction, but it can exercise no other. The duty of a government to afford protection is limited always by the power it possesses for that purpose. Experience made the fact known to the people of the United States that they required a national government for national purposes. The separate governments of the separate states, bound together by the Articles of Confederation alone, are not sufficient for the promotion of the general welfare of the people in respect to foreign nations, or for their complete protection as citizens of the Confederated States. For this reason, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for page 92 U.S. 550 the common defense, promote the general welfare, and secure the blessings of liberty to themselves and their posterity. Const. Preamble ordained and established the government of the United States and defined its powers by a constitution, which they adopted as its fundamental law and made its rule of action. The government thus established and defined is to some extent a government of the states in their political capacity. It is also, for purposes, a government of the people. Its powers are limited in number but not in degree. Within the scope of its powers as enumerated and defined, it is supreme and above the states. But beyond it has no existence. It was erected for special purposes and endowed with all the powers necessary for its own preservation and the accomplishment of the ends its people had in view. It can neither grant nor secure to its citizens any right or privilege expressly or by implication placed under its jurisdiction. The people of the United States resident within any state are subject to two governments, one state and the other national. But there need be no conflict between the two. The powers which one possesses the other does not. They are established for different purposes and have separate jurisdictions. Together they make one whole and furnish the people of the United States with a complete government for the protection of all their rights at home and abroad. True, it may sometimes happen that a person is amenable to both jurisdictions for one and a same act. Thus, if a marshal of the United States is unlawfully resisted while executing the process of the courts within a state, and the resistance is accompanied by an assault on the officer, the sovereignty of the United States is violated by the resistance, and that of the state by the breach of peace in the assault. So too, if one passes counterfeited coin of the United States within a state, it may be an offense against the United States and the state. The states because it discredits the coin, and the state because of the fraud upon him to whom it is passed. This does not, however, necessarily imply that the two governments possess powers in common or bring them into conflict with each other. It is the natural consequence of a citizenship, page 92 U.S. 551, which owes allegiance to two sovereignties and claims protection from both. The citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalties which each exacts for disobedience to its laws. In return, he can demand protection from each within its own jurisdiction. The government of the United States is one of delegated powers alone. Its authority is defined and limited by the Constitution. All powers not granted to it by that instrument are reserved to the states or the people. No rights can be acquired under the Constitution or laws of the United States, except such as the government of the United States has the authority to grant or secure. All that cannot be so granted or secured are left under the protection of the states. We now proceed to an examination of the indictment to ascertain whether the several rights, which it is alleged the defendants intended to interfere with, are such as have been in law and in fact granted or secured by the Constitution or laws of the United States. The first and ninth counts state the intent of the defendants to have been to hinder and prevent the citizens named in the free exercise and enjoyment of their lawful right and privilege to peaceably assemble together with each other and with other citizens of the United States for a peaceful and lawful purpose. The right of the people peaceably to assemble for lawful purposes existed long before the adoption of the Constitution of the United States. In fact, it is, and always has been, one of the attributes of citizenship under a free government. It derives its source, to use the language of Chief Justice Marshall in Gibbons v. Ogden 9 W. 122 U.S. 211, from those laws whose authority is acknowledged by civilized man throughout the world. It is found wherever civilization exists. It was not, therefore, a right granted to the people by the Constitution. The government of the United States, when established, found it in existence with the obligation on the part of the states to afford it protection. As no direct power over it was granted to Congress, it remains, according to the ruling Gibbons v. Ogden ID 22 U.S. 203, subject to state jurisdiction, page 92 U.S. 552. Only such existing rights were committed by the people to the protection of Congress as came within the general scope of the authority granted to the national government. The First Amendment to the Constitution prohibits Congress from abridging the right of the people to assemble and to petition the government for a redress of grievances. This, like the other amendments proposed and adopted at the same time, was not intended to limit the powers of the state governments in respect to their own citizens, but to operate upon the national government alone. Barron v. The City of Baltimore 7 250 Livingston v. Moore ID 551 Fox v. Ohio 5 Howe 434 Smith v. Maryland 18 ID 76 Withers v. Buckley 20 ID 90 Previer v. The Commonwealth 5 Wall 479 Twitchell v. The Commonwealth 7 ID 321 Edwards v. Elliott 21 ID 557. It is now too late to question the correctness of this construction. As was said by the late Chief Justice in Twitchell v. The Commonwealth 7 Wall 325, the scope and application of these amendments are no longer subjects of discussion here. They left the authority of the states just where they found it and added nothing to the already existing powers of the United States. The particular amendment now under consideration assumes the existence of the right of the people to assemble for lawful purposes and protects it against encroachment by Congress. The right was not created by the amendment, neither was its continuance guaranteed except as against congressional interference. For their protection in its enjoyment, therefore, the people must look to the states. The power for that purpose was originally placed there and has never been surrendered to the United States. The right of the people peaceably to assemble for the purpose of petitioning Congress for a redress of grievances or for anything else connected with the powers or the duties of the national government is an attribute of national citizenship and as such under the protection of and guaranteed by the United States. The very idea of a government republican in form implies a right on the part of its citizens to meet peaceably for consultation in respect to public affairs and to petition for redress of grievances. If it had been alleged in page 92 U.S. 553 these counts that the object of the defendants was to prevent a meeting for such a purpose, the case would have been within the statute and within the scope of the sovereignty of the United States. Such, however, is not the case. The offense as stated in the indictment will be made out if it be shown that the object of the conspiracy was to prevent a meeting for any lawful purpose whatever. The second and 10th counts are equally defective. Right there specified is that of bearing arms for a lawful purpose. This is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. The Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress. This is one of the amendments that has no other effect than to restrict the powers of the national government, leaving the people look for their protection against any violation by their fellow citizens of the rights it recognizes to what is called in the City of New York v. Milne 11 Pet. 139, the powers which relate to merely municipal legislation, or what was perhaps more properly called internal police, not surrendered or restrained by the Constitution of the United States. The 3rd and 11th counts are even more objectionable. They charge the intent to have been to deprive the citizens named, they being in Louisiana, of their respective several lives and liberty of person without due process of law. This is nothing in alleging a conspiracy to falsely imprison or murder citizens of the United States, being within the territorial jurisdiction of the state of Louisiana. The rights of life and personal liberty are natural rights of man. To secure these rights, says the Declaration of Independence, governments are instituted among men, deriving their just powers from the consent of the governed. The very highest duty of the states, when they entered into the Union under the Constitution, was to protect all persons within their boundaries in the enjoyment of these unalienable rights with which they were endowed by their Creator. Sovereignty, for this purpose, rests alone with the states. It is no more the duty or within the power of the United States to punish for a conspiracy, page 92 U.S. 554, to falsely imprison or murder within a state than it would be to punish for false imprisonment or murder itself. The 14th Amendment prohibits a state from depriving any person of life, liberty, or property without due process of law, but this adds nothing to the rights of one citizen as against another. It simply furnishes an additional guarantee against any encroachment by the states upon the fundamental rights which belong every citizen as a member of society, as was said by Mr. Justice Johnson in Bank of Columbia v. Oakley for Waite, 244. It secures the individual from the arbitrary exercise of the powers of government, unrestrained by the established principles of private rights and distributive justice. These counts in the indictment do not call for the exercise of any of the powers conferred by this provision in the amendment. The 4th and 12th counts charge the intent to have been to prevent and hinder the citizens named who were of African descent, persons of color, in the free exercise and enjoyment of their several right and privilege to the full and equal benefit of all laws and proceedings then and there before that time enacted or ordained by the said state of Louisiana and by the United States, and then and there at that time being in force in the said state and district of Louisiana aforesaid for the security of their respective persons and property then and there at that time enjoyed at and with said state and district of Louisiana by white persons being citizens of said state of Louisiana and the United States for the protection of the persons and property of said white citizens. There is no allegation that this was done because of the race or color of the persons conspired against. When stripped of its verbiage, the case as presented amounts to nothing more than that the defendants conspired to prevent certain citizens of the United States, being within the state of Louisiana, from enjoying the equal protection of the laws of the state and of the United States. The 14th Amendment prohibits a state from denying to any person within its jurisdiction the equal protection of the laws, but this provision does not any more than the one which precedes it, in which we have just considered, add anything page 92 U.S. 555 to the rights which one citizen has under the Constitution against another. The equality of the rights of citizens is a principle of republicanism. Every republican government is in duty bound to protect all its citizens in the enjoyment of this principle if within its power. That duty was originally assumed by the states, and it still remains there. The only obligation resting upon the United States is to see that the states do not deny the right. This the amendment guarantees, but no more. The power of the national government is limited to the enforcement of this guarantee. No question arises under the Rights Act of April 9, 1866, 14 Stat. 27, which is intended for the protection of citizens of the United States in the enjoyment of certain rights without discrimination on account of race, color, or previous condition of servitude, because, as has already been stated, it is nowhere alleged in these counts that the wrong contemplated against the rights of these citizens was on account of their race or color. Another objection is made. These counts that they are too vague and uncertain. This will be considered hereafter in connection with the same objection to other counts. The 6th and 14th counts state the intent of the defendants to have been to hinder and prevent the citizens named being of African descent and colored in the free exercise and enjoyment of their several and respective right and privilege to vote at any election to be thereafter by law had and held by the people in and of the said state of Louisiana, or by the people of and in the parish of Grant aforesaid, in Minor v. Happersett 21 Wall. 170. We decided that the Constitution of the United States has not conferred the right of suffrage upon anyone, and that the United States have no voters of their own creation in the states. In United States v. Risa et al. Supra p. 92 U.S. 214, we hold that the 15th Amendment has invested the citizens of the United States with a new constitutional right, which is exemption from discrimination in the exercise of the elective franchise on account of race, color, or previous condition of servitude. From this it appears that the right of suffrage is not a necessary attribute of national citizenship, but that exemption from discrimination in the exercise of that right on 92 U.S. 556 account of race and is the right to vote in the states comes from the states, but the right of exemption from the prohibited discrimination comes from the United States. The first has not been granted or secured by the Constitution of the United States, but the last has been. Inasmuch, therefore, as it does not appear in these counts that the intent of the defendants was to prevent these parties from exercising their right to vote on account of their race, and it does not appear that it was their intent to interfere with any right granted or secured by the Constitution or laws of the United States, we may suspect that race was the cause of the hostility, but it is not so averred. This is material to a description of the substance of the offense, cannot be supplied by implication. Everything essential must be charged positively and not inferentially. The defect here is not in form, but in substance. The 7th and 15th counts are no better than the 6th and 14th. The intent here charged is to put the parties named in great fear of bodily harm, and to injure and oppress them, because, being and having been in all things qualified, they had voted at an election before that time had and held according to law by the people of the state of Louisiana in said state, twit, on the 4th day of November A.D. 1872, and at divers other elections by the people of the state also before that time had and held according to law. There is nothing to show that the elections voted at were any other than state elections, or that the conspiracy was formed on account of the race of the parties against whom the conspirators were to act. The charge as made is really of nothing more than a conspiracy to commit a breach of the peace within a state. Certainly it will not be claimed that United States have the power or are required to do mere police duty in the states. If a state cannot protect itself against domestic violence, the United States may, upon the call of the executive, when the legislature cannot be convened, lend their assistance for that purpose. This is a guarantee of the Constitution, art. 4 sect. 4, but it applies to no case like this. We are therefore of the opinion that the 1st, 2nd, 3rd, 4th, 6th, 7th, 9th, 10th, 11th, 12th, 14th, page 92 U.S. 557 and 15th counts do not contain charges of a criminal nature made indictable under the laws of the United States, and that consequently they are not good and sufficient in law. They do not show that it was the intent of the defendants by their conspiracy to hinder or prevent the enjoyment of any right granted or secured by the Constitution. We come now to consider the 5th and 13th and the 8th and 16th counts may be brought together for that purpose. The intent charged in the 5th and 13th is to hinder and prevent the parties in their respective free exercise and enjoyment of the rights, privileges, immunities, and protection granted and secured to them respectively as citizens of the United States and as citizens of said state of Louisiana, for the reason that they, being then, and their citizens of said state and of the United States were persons of African descent and race and persons of color and not white citizens thereof, and in the 8th and 16th to hinder and prevent them in their several and respective free exercise and enjoyment of every, each, all, and singular the several rights and privileges granted and secured to them by the Constitution and laws of the United States. The same general statement of the to be interfered with is found in the 5th and 13th counts. According to the view we take of these counts, the question is not whether it is enough in general to describe a statutory offense in the language of the statute, but whether the offense has here been described at all. The statute provides for the punishment of those who conspire to injure, oppress, threaten, or intimidate any citizen with intent to prevent or hinder his free exercise and enjoyment of any or privilege granted or secured to him by the Constitution or laws of the United States. These counts in the indictment charge in substance that the intent in this case was to hinder and prevent these citizens in the free exercise and enjoyment of every, each, all, and singular the rights granted them by the Constitution, and there is no specification of any particular right. The language is broad enough to cover all. In criminal cases prosecuted under laws of the United States, the accused has the constitutional right to be informed, page 92 U.S. 558 of the nature and cause of the accusation. Amen. Romans, United States v. Mills 7 pet. 142. This was construed to mean that the indictment must set forth the offense with clearness and all necessary certainty to apprise the accused of the crime with which he stands charged, and in United States v. Cook 17 Wall. 174. That every ingredient of which the offense is composed must be accurately and clearly alleged. It is an elementary principle of criminal pleading that, where the definition of an offense, whether via common law or by statute, includes generic terms, it is not sufficient that the indictment shall charge the offense in the same generic terms as in the definition, but it must state the species, it must descend to particulars, 1 arch, yar, and lace 291. The object of the indictment is, first, to furnish the accused with such a description of the charge against him as will enable him to make his defense and avail himself of his conviction or acquittal for protection against a further prosecution for the same cause, and second, to inform the court of the facts alleged so that it may decide whether they are sufficient in law to support a conviction, if one should be had. For acts are to be stated, not conclusions of law alone. A crime is made up of acts and intent, and these must be set forth in the indictment with reasonable particularity of time, place, and circumstances. It is a crime to steal goods and chattels, but an indictment would be bad that did not specify with some degree of certainty the article stolen. This because the accused must be advised of the essential particulars of the charge against him, and the court be able to decide whether the property taken was such as was the subject of larceny. So too it is in some states a crime for 2 or more persons to conspire to cheat and defraud another out of his property, but it has been held that an indictment for such an offense must contain allegations setting forth the means proposed to be used to accomplish the purpose. This because to make such a purpose criminal, the conspiracy must be to cheat and defraud in a mode made criminal by statute, and as all cheating and defrauding has not been criminal, it is necessary for the indictment to state the means proposed in order that the court, page 92 U.S. 559 may see that they are in fact illegal. State v. Parker 43 N. H. 83, State v. Keach 40 VT 118. Alderman v. The People for Mitch 414, State v. Roberts 34 Me 32. In Maine it is an offense for 2 or more to conspire with the intent unlawfully and wickedly to commit any crime punishable by imprisonment in the state prison, State v. Roberts, but we think it will hardly be claimed that an indictment would be good under this statute, which charges the object of the conspiracy to have been unlawfully and wickedly to each, every, all, and singular the crimes punishable by imprisonment in the state prison. All crimes are not so punishable. Whether a particular crime be such a one or not is a question of law. The accused has, therefore, the right to have a specification of the charge against him in this respect, in order that he may decide whether he should present his defense by motion to quash, demurrer, or plea, and the court that it may determine whether the facts will sustain the indictment. So here, the crime is made to consist in the unlawful combination with an intent to prevent the enjoyment of any right granted or secured by the Constitution. All rights are not so granted or secured. Whether one is so or not is a question of law to be decided by the court, not the prosecutor. Therefore, the indictment should state the particulars to inform the court as well as the accused. It must be made to appear, that is to say, appears from the indictment without going further, that the acts charged will prove support a conviction for the offense alleged, but it is needless to pursue the argument further. Conclusion is irresistible that these counts are too vague and general. They lack the certainty and precision required by the established rules of criminal pleading. It follows that they are not good and sufficient in law. They are so defective that no judgment of conviction should be pronounced upon them. The order of the circuit court arresting the judgment upon the verdict is therefore affirmed and the cause remanded, with instructions to discharge the defendants.